Hello, my name is Brianna Schrader, and I'm an attorney at Jansen Ag Law. This is another 10-minute webcast. It's part of a series of educational webcasts that we've designed for busy people. We've limited these webcasts to about 10 minutes, so you can watch them while you eat lunch or you're sitting in line. Since we only have 10 minutes, let's get going. Today's webcast is about what to do if your agricultural operation experiences a workplace injury. Ag operations are at risk for potentially serious workplace injuries. Employees work with large animals, slick surfaces, sharp edges, heavy machinery, and potentially dangerous equipment. What should an employer do if and when a workplace injury occurs? First, seek medical attention. As an employer, as soon as you learn of any kind of workplace injury, you should seek medical attention for the injured employee. A failure to provide your employee immediate medical attention not only negatively impacts the employee and his coworkers, but it could also be legally problematic in the future. Call 911 if the injury is serious. The address and the buildings involved in your operations should be clearly marked so emergency personnel can find you. If it is not serious, provide immediate first aid assistance as needed and then encourage the employee to seek medical care as soon as possible. It goes without saying that an agricultural operation or farm should have a fully stocked first aid kit somewhere on hand. Employees should contact a designated manager or owner or supervisor anytime an injury occurs on the job. Employees should report to their direct supervisor or an owner of the company. If the employees are working a late shift or no one is present, they should use the phone to notify the appropriate supervisor. The immediate reporting is important not only so that proper medical care can be given, as we just discussed, but also so the employer can properly report the injury, if needed, to OSHA and the workers' compensation carrier. Regardless of the workers' comp coverage, detailed records are key. First, write a narrative of what happened. Include the employee name and address, the time and date of injury, where the injury occurred, the type of injury, a narrative including the cause of the injury, names of witnesses, and whether any kind of equipment was involved. It's also helpful to include the actual witnesses' statements, including their full names and contact information, and photographs of the area or machinery involved in the injury. This information will be helpful for workers' compensation claims, potential lawsuits, and to figure out what went wrong so it can be prevented in the future. Employers generally should develop a form to use to record this information after any injury. The site of any serious accident should be secured for investigative purposes. Should limit access to the scene of the incident to avoid other accidents, then secure and save any equipment that was involved in the accident. All employers, regardless of size, are required to notify OSHA when an employee is killed on the job or suffers a work-related hospitalization, amputation, or loss of an eye. A fatality must be reported within 8 hours. A hospitalization, amputation, or eye loss must be reported within 24 hours. OSHA has an online serious event reporting link that you can access here. I'll put these materials online so you have easy access to this link. As you can see, this is the U.S. Department of Labor Serious Event Reporting Online form. When you fill out that form, be prepared to supply the business name, names of employees affected, location and time of the incident, brief description of the incident, your contact person and phone number. Employers do not have to make this report if the event or the accident resulted from a motor vehicle accident on a public street or highway, unless it was a construction work zone, or if it occurred on a commercial or public transportation system, like an airplane or a bus. Under the OSHA record-keeping regulations, employers are required to prepare and maintain records of work-related injuries and illnesses using OSHA Form 300. There are some exemptions, but agricultural operations with 20 to 249 employees must submit an annual injury and illness summary, which is Form 300A. Must submit this data to OSHA electronically once a year. And again, there is an online form link that you can use here to track injuries once you have your username or login information. Some employers might be hesitant to report any injuries to the government because they might employ a large immigrant labor force, but OSHA should not require regarding any workers' immigration status. So the next step is to cooperate with your workers' compensation carrier. Now, not all agricultural operations are required to have workers' comp insurance, but if you do, the employer should provide a workers' compensation claim form to be filled out. The employee would fill out part of it and sign it, and then the employer also fills out a part of that form and signs the other section. You can check with your insurance carrier for available resources. Here's an example of such a form from a carrier. This is actually from the state of Indiana, and it's a first report of employee injury or illness. As you can see, this is the kind of information that would be requested from any workers' comp carrier. This is just an example. Check with your carrier or your state for specific information. If you do have workers' comp or other insurance coverage, cooperate with the carrier and its attorneys. They'll likely ask for documentation. This is the fun part of doing a live webcast. Insurance carriers would likely ask for documentation related to the injury. They'll also ask for other information, probably from the employee's personnel file. An insurer might send an adjuster out to take recorded statements from the employee, supervisors, or coworkers. You might have your lawyer be present during any such recorded statements to protect your own interests. Cooperate with the workers' comp insurance carrier and its attorneys, but I would say if contacted by an injured employee's attorney or another entity seeking information about the injury, you should immediately contact your own attorney to determine how or whether you should respond. An important next step is to prevent future injuries. Examine the cause of the injury and eliminate those future hazards. Use what you've learned from the injury reporting and investigation process to reduce risks and eliminate hazards. This could include posting signs of slippery floors or low overhead spaces. It can also include holding safety training meetings with your employees. Employees generally need adequate resources to be safe on the job. For example, employees who work with livestock might need non-slip shoes, gloves, or other equipment to keep them safe. Employees who work with heavy equipment like tractors should be trained on how to use it. And employees who handle sharp tools or cutting items should have safety equipment available. Employers should regularly inspect the work area for potential hazards and conduct any needed repairs. Appropriate inspections and maintenance can prevent many costly injuries. One key here is just to communicate with your employees about what they're doing, what they need, and what hazards they see. The next step, equally important, is to welcome the employee back. To help injured or ill employees become productive again as quickly and safely as possible, employers should implement a return to work or modified job program. These programs can help keep workers off of long-term disability and might be able to lower employers' costs. So keep in touch with your injured employee and determine whether they can come back full-time or if modified duties are necessary. Consult your employment attorney if you have questions regarding transitional or return-to-work arrangements. It's important to note that if you do have workers' comp insurance, you cannot penalize or terminate an employee for the mere fact that they filed a workers' comp claim. Employment law prohibits retaliation against an employee simply for filing a workers' comp claim. There might be other issues related to the employee's performance that may give rise to discipline, but filing a workers' comp claim cannot. So, to do a quick review, if you have an employee get injured on the job, first make sure he or she receives appropriate medical attention. Record details and report the injury as needed to federal and state OSHA and your workers' comp carrier. Cooperate with any investigation, but don't be afraid to involve your own lawyer to protect your company's interests. Prevent future injuries through maintenance and safety training, and welcome your employee back to the job. So that's today's 10-minute webinar. I hope you enjoyed it. Please return in December after the Thanksgiving holiday for my colleague Todd Jansen's next webcast. You can contact me at schrader@aglaw.us. Please visit aglaw.us for more information on this topic and others.